Nick, we're going to absolutely jump into the next question. And this one, I believe, involves basically what we have here is something that was actually trending on social media. And what was there is that there was basically a big red notice on a tenant's door that basically said, please pay your rates and accounts as they are behind. Contact this number also to avoid legal action taken against you. So this was inside an estate or development stuck right by the door for anybody, the neighbors to see, etc. So basically what this tenant then did, took a picture of that, put it on social media. Obviously the sign had been there for quite some time. And so they posted on social media, Nick, and they asked basically for people's input. The first question they asked is this illegal? And if it's not legal, what type of rights are being violated here? Is it a matter of appropriate, or is it a matter of defamation of character? So maybe, Nick, you can just dive into that and provide some clarity as to, is it legal, is it not legal? And yeah, we can take it from there. Maybe Bruno can also jump in.
So it's one of those examples that we have where, you know, landlords are endlessly creative when it comes to collection of arrear amounts from their tenants. And we've talked a lot on this channel about spoliation. You know, and obviously spoliation is we'll go again, the deprivation of one's use and enjoyment of a particular premises, their possession of it. And this is a clever one because it's a notice on the door. So we've obviously talked a lot on this channel about you can't, you know, break locks or change a door or put someone inside the premises that your tenant is to try and force them to either vacate or pay arrears. But this is a notice. So it doesn't extend as far as to destroying the possession of your tenants or the occupants of the property. In the circumstances, you're not preventing them from going in and out or using that property, but obviously, you know, the notice is there where other people can see it. So the first thing on a spoliation basis, that's the first place that we'd look. I don't think it falls under spoliation per se. You haven't taken away any, you know, possession that they have, so not spoliation. That then moves us on to the other questions, poppy or defamation. Now, without the actual content of the particular notice, unfortunately, I can't give a clear answer on poppy. It's very unlikely that anything in the notice is going to fall, you know, foul of poppy. The landlord or developer, whoever put up the notice in the circumstances, would have had to have been really negligent in the circumstances where they gave away personal information that they'd been given by this particular individual on a public notice. But if they did do something like that, then they're going to have some problems. Really, you can't do that, but it's unlikely. I mean, you're not going to go up there and go, you know, this is your personal information, this is your banking details, or whatever the case is. It seems unlikely they do that. I think the notice would more be for the public side to say, well, we're going to let people know that you're falling foul of your obligations for paying levies in terms of the estate. So now this brings us into the realm of defamation. Okay, so now defamation obviously is diminishing or destroying one's character publicly, for which there are claims that people can have. Okay, so it seems it would fall in the realm of defamation, but there's one thing about defamation. Defamation is one thing, and in our law there are certain categories of information which is published, which is acceptable and is basically a counter to defamation. So where there would normally be defamation, the law says, but in these particular circumstances, it may be okay. All right. And then in this particular circumstance, what I foresee is that the developer or the landlord, whoever put up this notice, is going to be able to rely on the truthfulness of this particular assertion. Now, it's not simply good enough that the thing that you said is simply true and you can get off scot-free. It may well be true, and that would be the first inquiry that we look into. So the example is, if the developer posts on your door and says you're in arrears for your levies or whatever the case is, and it's simply not true, and they've lied about it, that's a very easy inquiry. You've obviously defamed. You obviously defamed the person in the circumstances because you're telling libels about them. All right, but again, it's very unlikely that a developer is going to go to the effort and the cost of doing this when it's not true in the circumstances. So let's go from the assumption that it is true. The second part of this inquiry is public interest. Okay, so even if something is true, there's got to be some level of public interest where you say, well, it is in the interest of the public that I publish this particular item. Okay, and that's the second inquiry. And that one is a little bit more interesting in the circumstances because obviously the argument here, I imagine from the tenant's sake, well, it's not in the public interest whatsoever. But there is an argument to be made that because this exists within an estate, where all of the parties that live within this estate are expected to contribute within their own, specific square meterage within that estate towards levies, electricity, water, whatever the case is. It may well be in the interest of that particular estate to know who is in fact in arrears in the estate, because the other owners within that particular estate may be the ones who are now carrying the costs as a result of the failure of certain individuals within the estate to actually pay their levies, water, electricity timeously. So there is certainly an argument to be made that this might be in the public interest, within the particular estate. If the developer went and published this information, the person's name, they're not paying their levies on a billboard, on the N1, they're not going to have much of an argument to say that's in the public interest. I don't think people just driving along the N1 are interested. But if this is published on the door within the particular estate and it's seen by the neighbors, I think there's a sufficient argument to be made that this is within their interest at the very least. Because their levies are covering what balance is left over by the non-paying owner. The other problem with this particular question is obviously, if this owner wanted to go and now claim defamation against the people who had posted the notice, they've done themselves a massive injustice by going to social media and then posting the notice. Because at that point, you've now published it yourself. You can't be that hurt, or that defamed that you're willing to go and post it on social media. So unfortunately, for that person looking for, what their relief would be, I feel they may have, done themselves in at that point, because now they've published it way wider than the developer would have. But, that's the lesson we learned.
Exactly. Yeah, absolutely. Yeah.
Yeah. Well, I think Nick, that sums up the answer pretty much well. That is, ladies and gentlemen, for today, and we'll see everybody again next week. Thank you very much.
Thanks so much, guys.
Thanks, guys. See you next week.